Cool. Good morning, everyone, and welcome to this Fieldfisher webinar today. We are going to be looking at some of the recent developments that impact online tracking, and in particular, the use of cookies and other tracking technologies in Europe. Those of you who have kind of been following this particular space will be aware that we've had loads of interesting developments, both regulatory developments and also industry developments that have happened in the last few months. And it seems to me that this is an area where kind of changes and developments almost seem to be happening on a weekly, daily basis. So, you know, lots to talk about in this webinar, and we're really going to sort of take you through some of the recent developments, talk about some of their practical impact, and hopefully have an interesting discussion about all of this. Just to give you an introduction to my fellow panelists today, I've got Paul Lanois, who's a director in our team, and fantastic Richard Lawn. All of us are based out here in our Silicon Valley office, and I should also say I'm Felicity Fisher, a partner out here in the office too. We've got 45 minutes to take you through some of these issues, and I think Richard is going to kickstart with just level setting and giving a kind of background into what the law says at the moment, and then we're going to take a kind of more a look at the recent developments that have happened in the last few months, and also just give a bit of discussion, or have a bit of a discussion around what all of this means in practice. But before we get started with today's content, just a bit of housekeeping. For those of you who are sort of regular listeners into our webinars, thanks very much for joining us again. Just a reminder that if you want to go back and listen to any of our other previous webinars, we have a YouTube channel, so you can go back and have a look at some of our previous content. We also have a podcast now, which you can find in all the usual spaces. And we also have a blog, which I highly recommend that people subscribe to if you're interested in privacy-related topics. It is really, really good. And excuse my slightly chattering voice. I've just been for a swim in the San Francisco Bay and haven't had a time to have my usual hot shower. So excuse me, I do sound a little bit cold, but I'm sure I'll warm up in the next 45 minutes. Right, so just to get kick-started, I think I'm going to hand this over to Richard. He can also explain what we've done with the slides to give it a bit of a musical theme to spice things up. So over to you, Richard, to get things going.
Hi, thanks, Flick, and good morning, everyone. Sorry, I've been fiddling around with the presentation a little bit because I'm struggling to get it to present in full screen mode. I am not a technician, and so trying to figure this out remotely it's not working. But we'll go ahead, and if you see the notes or anything like that, then that's just the way it's going to be. So when we were preparing for this webinar, we were conscious of the fact that most, if not all of you, have been in some form of quarantine or lockdown the last few months, and you've probably at this point in time attended quite a few webinars or online events. So to make things a little bit more interesting, maybe even fun, we'll see about that, we thought we would adopt a jukebox theme for the slide deck. Or maybe rather an iPod playlist theme. So for each slide, we've assigned that slide the title of a song. And at the end of the webinar, in about 45 minutes, we will reveal who the artists are for those song names. So just to yourselves, you might want to have a guess as we go along who the artists are. And by the way, it has absolutely nothing to do with the topic today. It's completely unrelated. We just thought it'd make it a little bit more fun. So without further ado, we should probably crack on because we've got quite a lot to cover. So the first thing that we thought we would do is touch base on what are the laws and the rules that currently apply in Europe around online tracking. Now, the first important thing to say is that in Europe, online tracking is governed by two separate pieces of law. So the first one is the e-privacy directive. Now, this is the directive that contains the so-called cookie law under Article 5.3, which states that if you are storing information on or gaining access to information stored on a device, then you need to obtain the user's consent to do so. And you also have to provide the user with clear and comprehensive information about the tracking that you are performing. Now, there are 3 notes to point out here. The first is that this rule applies to any form of tracking. It doesn't just apply to tracking through cookies, it applies to tracking through all other forms of tracking technologies as well, like local storage objects, flash cookies, GIFs, pixels, SDKs, you name it. It's going to be any tracking that you're performing. The second note is that it also applies to any form of data collection. So we're not just talking about personal data. If you are accessing information about a user's device, their browser, whether personal or not, then the e-privacy rules are going to apply. The third point to quickly mention is that there is an exemption to the consent requirement for tracking that is strictly necessary, i.e. it's essential to provide a service that the user has explicitly requested. But that is a fairly narrow exemption, and it doesn't apply to most forms of tracking, and it's not going to be relevant for the tracking that we're really going to be discussing today, tracking like analytics, personalization, and targeted advertising, those purposes. Now, apart from the e-privacy directive, we also need to be thinking about the GDPR as well. And the reason why the GDPR is relevant to online tracking is twofold. Firstly, it's because consent under the e-privacy directive is defined with reference to the GDPR. So to obtain consent under e-privacy, you have to obtain consent to the standard required under the GDPR. The second reason is perhaps more obvious, and that's because for most instances of online tracking, you are also going to be processing personal data too. And that's because you're obtaining information that's associated with one particular user or individual. So the short of it is that when we're talking about online tracking, most of the time we're looking at that center ground of the Venn diagram, and we need to be thinking about both the e-privacy directive and the GDPR as well. Now that brings us on to the second important thing to mention about European rules, and that is that you need opt-in consent to perform any form of tracking. Just seeing whether we are moving on to the next slide here. So just bear with me and I'll bring that back up. Okay, hopefully that's displaying. So if you are performing online tracking in Europe, then you need to obtain the user's opt-in consent. And this is because under the GDPR, consent must be freely given, it must be specific, it must be informed, and it also has to be unambiguous. And it's this last part that really leads us to opt-in consent, because for consent to be unambiguous, that means that the user has to give a clear and affirmative action indicating their consent. That's why when the GDPR came into effect in 2018, from that point in time, we knew that implied consent or consent that relies on a pre-checked box or slider was not going to be valid because it was not unambiguous and it wasn't opt-in. The other thing to quickly mention about consent under the GDPR is that consent must be able to be withdrawn at any time, which means that not only do you have to obtain the user's opt-in consent at the beginning, before you perform any non-essential tracking, then you also need to give the user the ability to opt out from tracking later on as well. Now, I don't know if Paul is on the line. Paul, are you with us?
Hi, yeah, sorry, I was a bit late.
So
I think you're on the wrong. Oh, sorry, you wanted to change the slide order, or?
Sorry, if we go back a bit. Yeah.
Here we are. So I was just going to hand over. Yeah, go ahead, Flick.
Just before Paul says anything, I think it's also just worth bearing in mind that the law that Richard has just described is the reason why when you go on a European-facing website that you are presented with those big cookie banners that pop up and ask you to consent to the use of cookies on the website. So this law is all driving at the need to provide both transparency and get a clear permission from the user to do that tracking. And as Richard mentioned, technically the law requires that you get that consent before any cookies are fired or dropped on the website, which clearly creates some of the challenge here. The other reason why we've got a lot of challenge in trying to meet these compliance requirements is to kind of meet that standard of consent. One of the things that Richard has flagged there is that it has to be specific consent. Well, obviously, if you are working with, multiple ad tech partners who will all be dropping cookies in the background on your website, you've now got to make sure that the user has very clear and comprehensive information. That was the law for a while, but now to meet that requirement for this consent to be valid, we have to be very sure that the user understands all of the third-party vendors that may be operating in the background to drop those cookies. And so that creates something of a compliance conundrum, because trying to deliver meaningful transparency so that you can get that valid consent is one of the problems that the industry, that is the ad tech industry, and working alongside publishers, is trying and grappling with to try and meet some of these requirements. So we know those cookie banners are there to comply with the law, but at the moment, a lot of the regulators are saying the level of transparency and choice presented is not necessarily sufficient. And we're going to get into more of that in a second. But sorry, back over to you, Paul, to talk about the recent Fashion ID case.
Thanks. One of the obligations which is imposed on website operators is to assess the relationship with third parties whose assets you deploy on the website. And this means that if you deploy social plugins, buttons, widgets, pixel trackers, social media sharing tools, or whatever, you should be aware of what data you are actually sending to third parties, and of the fact that you may be considered a controller in respect of the personal data which is being collected and disclosed to those third parties. And this position was clarified by the Court of Justice of the European Union in the Fashion ID case, which was issued in July 2019. And in that case, there was the operator of a website which included a social plugin, and that caused the transmission of data to a social media platform. And the court said that the website operator is directly responsible for complying with legal obligations in relation to such a transfer to the social plugin provider, including there is this obligation as well to inform users that their personal data will be transferred to the plugin provider. Now, the court had clarified that the website's operator's role as a data controller, as well as its corresponding legal obligation, is of course limited to the collection and the transmission of the data to the plugin provider. And the website operator is not responsible for the subsequent personal data processing that the plugin provider carries out. But then this ruling is particularly important because it covers third-party technologies which are often incorporated into websites, including cookies and pixels.
Yeah, I think the interesting thing about this case is that, before this case, people were often taking the position that the publisher and the ad tech partner that they were working with, who would be dropping a third-party cookie on their website, each of those parties, it was often the case that they would be arguing that they would be independent controllers of the information that was collected and processed. In some cases, some of the partners may have tried to take the view that they're a processor. Leaving aside that discussion, where both parties were acting as independent controllers, it meant that they were effectively free to determine what terms went into the contract. Because unlike when you're dealing with a controller and processor, the GDPR does not mandate or prescribe what terms have to go into a controller arrangement. However, as soon as there is any determination of joint controllership, we then need to think about Article 26 of the GDPR, which requires that the parties enter into a transparent arrangement in which the responsibilities for addressing compliance are clearly allocated. So who's going to provide notice, who's going to deal with data subject rights? And so off the back of this case, I certainly had an expectation that there would be more pressure on the contracts between publishers and their ad tech partners to address this joint controllership. But actually what's happened in practice is that I haven't seen that many changes being introduced into the standard controller terms. And to some extent that kind of makes sense, because if you were a behind the scenes controller dropping cookies on a website to support your the publisher partners targeted advertising, you already had to allocate responsibility for things like getting notice to individuals, asking the publisher to get consent on your behalf. And so to some extent, the contracts already were addressing that allocation of responsibilities. And I think as well that people have been a bit more careful about calling out a joint controllership, so that there was at least some ability to argue it down later down the line if you wanted to argue that actually people were acting as independent controllers. So I've seen it less clearly or less impact on the actual contractual terms than I would have expected off the back of this case. But it's just something to be aware of, that if there is any element of joint controllership, then technically we need to think about the Article 26 requirements in the GDPR, which will more specifically define what needs to be in the arrangement between the parties.
Great, thanks, Flick. So that's just a brief overview of the most important rules around online tracking as they stand today, but we don't want to spend too much time talking about the law. What we really want to focus on is at the heart of the discussion today. It's those big important developments that are taking place and which might impact the future of tracking as we know it. Now, there's obviously a lot we could talk about. We just want to focus on some of the biggest stories. Now, the first one of those stories is that despite these rules that we've described, if you take a step back, the position in Europe in terms of regulation is actually quite fragmented. Now, partly that's inevitable because the rules are contained in a directive, and a directive does not apply directly across the EU. It has to be implemented into national law by the various member states, and that leads to a difference of interpretation and implementation. But it's also caused by the fact that regulators take a different view on the e-privacy rules, how they interact with the GDPR, and they also have a different attitude in terms of enforcement. Now, there are some good examples of this fragmented position. The first is around analytics cookies. So in some countries, this is fairly straightforward. You need consent to track for analytics purposes. This is the case, for instance, in Spain. But in other countries, there might be certain exemptions. This is the case in Germany and France. So for instance, in France, they say if you're deploying certain types of analytics cookies, and those cookies meet the conditions that are set out in the CNIL's guidance on cookies, then that might fall within the strictly necessary exemption I mentioned earlier, and you don't need to obtain consent. Then there's also a third category of regulators who kind of tread a middle path between those two approaches. That's the case, for instance, with the UK ICO and also the Irish DPC, who both state that analytics cookies do require consent, but in the case of first-party analytics cookies, which don't involve intrusive tracking, that's unlikely to be an area of enforcement as their priority. So that's a good example where there are different approaches. Another example is on the topic of cookie walls. So cookie walls are essentially where a website, a platform, an app says to the user, well, you have to consent to tracking in order to access or use the service. And that's not just because we're using cookies and tracking that are essential to provide that platform, but also maybe because it's a free platform and it uses advertising to fund it, and therefore it needs to perform tracking to deliver personalized and targeted advertising. Now, the European Data Protection Board has said that cookie walls should not be permissible, and that's because under the GDPR, if you'll recall, consent has to be freely given, and therefore these two concepts are incompatible. And that approach has also been followed by some of the regulators, for instance, in Germany. However, some of the regulators take a more permissive approach. So in Austria and Spain, again, cookie walls are permissible in certain circumstances. And the UK ICO has also said that even though cookie walls are going to be invalid in most cases, that the GDPR also needs to be balanced against other interests, including the rights of a business to conduct its business freely, which kind of gives a very slim window for the possibility of cookie walls in certain cases. But this is also an example where actually the guidance is still evolving and in flux. So in France, the CNIL had issued guidance stating that cookie walls were impermissible as per the EDPB guidance, but that guidance issued by the CNIL was challenged in the French courts. And very recently, the highest administrative court in France ruled that the guidance was invalid and the CNIL could not reach that conclusion based on the GDPR's freely given consent requirement. Now that's quite a surprising decision. It's also left us in a state of slight confusion or slight limbo. Now, Paul, you are a French lawyer, you're French qualified. Do you have any comments and thoughts on this recent French decision?
Thank you, Richard. And indeed, the Conseil d'État, so the highest administrative court in France, did issue this decision, which is surprising. But then, when we look at the specifics of the ruling, what the Conseil d'État said was that the CNIL's position on cookie walls, because it is a general and absolute prohibition on the implementation of cookie walls, the Conseil d'État said that this is not permissible. And if I were to quote directly what the decision said, it said that I quote, by inferring such a ban from the sole requirement of the user's freely given consent to the use of tracking devices as imposed by the GDPR, the CNIL has exceeded what it could legally do in a so-called soft law instrument. And this is really important because the court is basically saying here that the issue that it has is that the general and absolute prohibition imposed by the CNIL cannot be imposed in a soft law instrument like this guideline. So there are different interpretations that you can have from this decision. The first one would be to say, well, here you go. You have the highest administrative court in France, which has overruled a decision by the CNIL, and it's in fact saying that cookie walls may be permitted in certain cases. However, when we look at the specifics, I don't think that's what the court was trying to say. I think what the court was trying to say was that this is not a decision on whether or not cookie walls are lawful. The decision is rather on the adequacy of the instrument, if I may call it that way, used by the CNIL to infer and to enact such a prohibition. What I think the court is trying to say here is that it is not possible to add on to the GDPR through interpretative guidelines. If we were going to say that cookie walls are never allowed, then it has to come from another instrument and not through the CNIL's guidelines. And interestingly, on the same day that the court published its decision, the CNIL issued a press release stating what happened, and the CNIL also stated that it takes note of the Conseil d'État's decision, and it's going to amend the guidelines accordingly to the extent strictly necessary.
So I guess we'll have to wait and see on that one. I believe also the CNIL has said that it won't be enforcing its guidance. It has a 6-month grace period following the final publication. So we'll see what its reissue guidance looks like. I just want to brief.
And since the final guidelines are not yet published anyway, so the 6 months timeframe hasn't started to run yet.
I just want to mention briefly also 2 other examples where we have a different approach by European regulators. The third one on that list is duration. This is both duration of cookies and information obtained via tracking, as well as the period for which the user's opt-in consent remains valid before you then need to reobtain consent from the user. Now, in the majority of cases, the regulators haven't ventured into this territory. They haven't set out any prescribed periods. And that's the case, for instance, with the UK. The ICO has said that the duration simply has to be proportionate to the use and also taking into account the potential impact and intrusion on the user. But in certain cases, the regulators have been more prescriptive. So notably in France, the CNIL has said that if you're deploying analytics cookies that fall into that strictly necessary exemption I mentioned earlier, they shouldn't be held for longer than 13 months. And both the CNIL and the IHDPC have said that you should be reobtaining consent from the user for tracking after 6 months. So, you know, things are not equal, and you need to, in some cases, look across the different positions and find a common denominator. The last example is the issue of lawful basis for processing under the GDPR. This is a perennial topic and a question that's been kind of unresolved for quite some time now. And here we're not talking about the lawful basis for the actual collection of data via cookies and other tracking technologies, because we know we need to obtain consent under e-privacy to do that. We're talking about the lawful basis for any subsequent processing of data collected via tracking, where you might be using that data for various purposes, and whether you need to rely on consent for those purposes as well, or whether you can rely on a non-consent basis like legitimate interests. I think the point to mention here is that none of the regulators, and the European Data Protection Board either, have come down with a position or a stance or provide us with an answer. And we think it's probably unlikely they will do so anytime soon, because given the current circumstances, it's not really a priority right now. A lot of the regulators have other things to be thinking about, COVID-19 not least. So this is an unresolved question which I don't think we'll have any immediate answers to.
Yeah, just to provide more flavour on that particular issue, for a long time, many of the ad networks and you know, SSPs and DSPs, who are again all behind the scenes doing that tracking, they for a long time have tried to argue that they should be able to rely on their legitimate interest to do lots of the processing that they do, so the personalisation and various other things that go on to support targeted advertising. And that, for many reasons, that argument was being made for practical reasons, because to have to get consent for all of those processing purposes again creates a whole world of practical compliance issue, because remember, we have to go and get consent that meets the GDPR standard, which is a high bar. So for a number of reasons, you know, it became a strategic argument that these ad tech companies were using to avoid having to get consent. But of course, you know, to some extent, you know, that does create a disconnect between the fact you've still got to get consent for collection, but now you're trying to rely on a non-consent ground for that additional processing. And some of the regulators, including the ICO, have sort of indicated that creates confusion for the end user in terms of understanding the grounds that are being used to rely on it. Also takes away from their ability to give clear choice or have control over how their data is processed. And so for a number of reasons, that ability to rely on that legitimate interest argument is not a clear-cut one. It's one that the regulators are looking into, and certainly the likes of the ICO, the UK regulator, have indicated in some of their guidance, although as Richard said, it's not been a firm view, they have indicated that may not be a solid legal ground to rely on in the context of the targeted advertising use case. So definitely something to keep an eye on. We've also got the fact that the e-privacy directive, which is the existing directive in place, is also set to be replaced by the new e-privacy regulation, which will when it comes into effect, the goal is that would rip up the existing data protection directive, all of the national implementations of it, and much like we saw with the GDPR, put in place one regulation that would effectively harmonize the rules across Europe. And now that piece of legislation has been ping-ponging its way through the legislative process in Europe. Effectively, it's been a very, very slow crawl through the legislative process, but we've seen the latest draft of that released by the EU presidency in March, and that recent draft indicated that there may be the ability to rely on legitimate interests to do some of that tracking through cookies, but there will be certain limitations to that. We'll see how far that draft gets, but it's an interesting development there that we should keep an eye on.
Yeah, and it's also hoped that regulation will add some clarity around things like tracking for measurement purposes and cookie rules, and some of these other areas which are currently a little unclear. But as Flick says, that's still in draft form, and it still has a way to go before we see what the final law will look like. So moving on from that European view, I think, Flick, you are now going to talk us through some of the actually potentially more impactful news in terms of platforms and what they are doing around tracking.
Yeah, absolutely. So we've obviously got the regulatory aspect here, which drives the need to come up with compliance solutions that will enable publishers and ad tech companies to actually comply with this. And we've seen a number of important industry developments that have come out in the last few months. And they really sort of indicate a growing trend towards giving users greater control of their online and mobile data. And we've really started to see the emergence of platforms and browsers starting to take the lead in figuring out how and controlling how some of this data collection is going to work in practice. So, many of you hopefully have dialed into this call will have heard that Google announced earlier this year that it was going to be phasing out third-party cookies over the next 2 years in its Chrome browser, which caused a massive stir in the ad tech world. So really, we're looking at a cookieless future by 2020, and Google basically wants ad tech measurement and fraud prevention to happen according to standards set by something it's calling the privacy sandbox. And really, through this privacy sandbox, the intention is that third-party cookies, and when we talk about third-party cookies, we're really talking about cookies that are set not by your own browser, but by a third party. So all of those ad tech partners, if you're a publisher, if you're a publisher and you're working with other partners to help you do your targeted advertising, all of the cookies that they're dropping would no longer be supported by the Chrome browser. And instead, if you want to be collecting any information to support that targeted advertising, you'd have to do it in accordance with the standards set by this privacy sandbox. And effectively what the privacy sandbox aims to do is to replace all of these cookies with 5 APIs that Google is currently developing. And essentially it means that advertisers will use each of these APIs to receive aggregated data about issues like conversion, so how well ads are being performed, and attribution, i.e. who's been purchasing the ads. And it's intended to really represent an alternative pathway that Google is attempting to provide for the ad industry. And really the goal here is, you know, they're kind of going to market saying that the goal of all of this is to better protect individuals' privacy and the security of the data that's being collected. But of course it creates a whole load of challenges for anybody, any third party who's relying on the ability to collect a load of information directly through the likes of cookies. So it's going to force a complete rethink over how the industry, you know, tracks users, or at least has historically collected information to support, you know, attribution, targeted advertising, all of that stuff. You know, there are also those of you who will have also heard about Apple's big announcement last week. Basically it has kind of said that it is going to be changing the way that its ad tracking controls work. So, and this was part of a number of announcements that it's made, but for the purposes of this you know, webinar, will focus on this particular issue. But you'll be aware that Apple has something called the IDFA, which stands for the ID for advertisers, and that's basically a unique identifier on your Apple iPhone. The Android has a similar ID. And unlike websites, mobile apps don't obviously use cookies, and instead they track you through collecting your ad ID, so your IDFA. And then that's used by, you know, mobile advertisers to do all sorts of things that they need to do to deliver those targeted advertisements, and also for attribution purposes. And historically, users had the ability to control who had access to that IDFA in their ad or limit ad tracking settings. And today these are buried basically within your privacy controls within your iPhone. But the recent changes are basically saying that with the launch of iOS 14, which is in autumn later this year, Apple's now going to force app developers who want to access your IDFA to require opt-in consent. So that means that users will have to be surfaced with a dialog box that asks them if they agree to XYZ company tracking them across apps and websites. And clearly this is this is going to have a huge impact, because it means that you're giving users much clearer control over whether or not they're tracked for targeted or tracked at all, and including for targeted advertising purposes. And clearly a number of users, if presented with the choice, are going to say, no, I do not want to be tracked. And so it really, you know, is going to call into question the ability for a number of apps who rely on targeted advertising to support those apps being provided for free. Is going to really undermine their ability to do that if they have to surface this opt-in consent, you know, before they can do that. So, you know, we're really starting to see the emergence of a struggle between the platform and browser providers on the one hand, who are under growing pressure from their users to provide more privacy-based controls, and then the advertisers and publishers on the other side, who will argue that they need ongoing access to your device-related data to enable targeted advertising to fund, you know, online and mobile content. The other thing that's interesting about this recent development is Apple is also going to effectively be controlling the access to the attribution data, i.e. the data that's needed for people to credit, you know, who has purchased a particular ad, or attribute the purchase to a particular advertiser, all of that type of attribution and campaign data, if third parties want to access it, they now have to go through something called the SDK ad network, which is Apple's privacy-centric mobile attribution framework. And in doing that, it's effectively positioning itself as the gateway to what advertisers can and can't know about users who install their apps for attribution purposes. And so again, it's a little bit unknown and unclear about what that means for third-party attribution providers, but clearly, if they want to, access the attribution data, they've either got to incorporate into that SK ad network, or they've got to rely on the publisher getting that clear opt-in consent for the IDFA, and that to include that consent to cover the sharing of that data for attribution purposes. So very interesting development, clearly one that the privacy advocates are going to like, but creates some challenges for industry and the funding of free apps and services. So that's definitely a huge development in the last week or so, and something to keep an eye on. The other thing to just keep people updated on is that we have got the IAB Transparency and Consent Framework. For those on the call, on the webinar, sorry, who are not familiar with this, this was an IAB initiative to create a standardized framework that publishers and ad tech vendors who do programmatic advertising could kind of use to, in a standardized way, collect and provide notice and consent to individuals around how their information is being used for ad targeting purposes. So it both was a framework that governed what should be presented and surfaced to users, and also how any consent strings and choice permissions should be then transmitted down and shared with everybody in the ad tech ecosystem. The original iteration of this framework was published or launched in April 2018. A number of publishers hated the first version. There were a couple of gaps that were seen to create a number of privacy issues. The regulators in some cases also started to challenge it as a framework. And so now we are now seeing the second iteration, which is TCF version 2.0, which is the new and improved framework. They've made a number of changes to it, including increasing the number of processing purposes from 5 to 12 to give all of the people in the chain more chance to identify different processing purposes and different grounds for different purposes. And importantly, also Google is going to be integrating into version 2.0, which is going to also help enormously, because at the moment Google effectively had its own consent requirements, and there were some issues with trying to integrate the two approaches. But Google's going to be going into TCF version 2.0, and that is going to basically, it's live now, but everybody has to integrate with it by the 15th of August, because they will no longer be supporting TCF version 1 as of the 15th of August. But definitely, if you are a publisher and you've got your consent management platform that you're working with, i.e. your cookie banner that pops up, if it's powered by the likes of OneTrust or others, you should be working with them to make sure that whatever you're going to be showing from the 15th of August, if you are somebody who's relying on the TCF framework, that it's updated to reflect the new version requirements. So I think I'm now handing over to Paul. I know I'm conscious we're running out of time, but I think Paul's just going to give a quick run through of some of the CCPA developments here. I think we'll give him 5 minutes to do that, and then we'll let you all get on with your day.
Oh boy, that's a tough one, right? Because the discussing this topic, and in particular the CCPA, I could go on for hours and hours, and I'll try to keep short and do it in only a couple of minutes. So, in relation to the CCPA, well, I'm sure most of you are aware of what the California Consumer Privacy Act is. The different requirements and so forth. So I'm not going to go through that. And in relation to how it applies to cookies, well, the text of the CCPA provides that whenever prior to or at a point a business collects personal information about a California resident, such business must notify the consumer about how it collects, uses, and discloses the information. And if a business sells information, as the term is defined in the CCPA, then there are certain obligations which are attached to it, including the fact that the business must disclose the sale, and it must provide the consumer with an opportunity to opt out of such sale, or otherwise, in some cases, to opt in the sale if the business knows that the consumer is a 15-year-old person or younger. And so it seems very straightforward when we look at it at first sight. But then, what does it really mean when we apply it to cookies? Well, third-party cookies can be used to identify a consumer or a household under the CCPA, and they are unique personal identifiers. Therefore, they would qualify as personal information. And so, some of you may be wondering, well, what does it really mean? How does deploying a third-party cookie on a website constitute a sale under the CCPA? Well, it's, as I mentioned earlier, a sale under the CCPA. The reason why I did that was that the concept of sale has a very specific definition under the CCPA, and it goes beyond the traditional concept of a sale. A sale under the CCPA means the selling, the renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating information to another business. And this is important because even the fact that you make available personal information to a third party under the CCPA could lead to the suggestion that you are actually doing a sale under the CCPA. And if that is the case, then even if you use a third-party cookie on the website, and even if you don't do anything else, there could be a possibility that this would be a sale of personal information under the CCPA. However, I think it's also important to raise the counter argument which exists and which is often used as well by many organizations at this stage, is that from a technical standpoint, it is possible as well to argue that there is no sale because third-party cookies are used to collect information by the third party directly, without the involvement of the business. So if we look just at the text of the CCPA, it's not really very clear as well what is the current situation in relation to cookies. And this issue is very important because, as I mentioned earlier, if there is a sale, then the business must provide a way for the user to opt out of such sale. And in particular, you need to have this conspicuous link, do not sell my personal information, on the website. So what are others doing? And in particular, we have, for example, the Network Advertising Initiative, the NAI, which is a leading self-regulatory association on digital advertising. And they have issued a number of documents, guidance, and they have updated their framework as well to take into account the CCPA. And in one of their guidance documents, they actually discuss the concept of sale under the CCPA, and they say, well, according to this NAI guidance document, the definition of sale needs to involve 3 different criteria. And the first criteria, so number 1, the use case must involve personal information. Well, that's quite straightforward, so I don't need to elaborate on that. The second point, the use case must involve the movement of personal information from one business to another business or a third party. And here there's already this suggestion that there needs to be transfer from one business to another business. And if that's not the case, then this may not qualify. And the third scenario will be the use case must involve the exchange of monetary or valuable consideration for the personal information. And if we look at their notes as well, they have stated that cases where a business collects personal information directly from a consumer would not typically fall within the concept of fail. And earlier this month in June, there was this the Office of the Attorney General in California issued the final regulations on the CCPA, and they have issued lots of different comments as well. And interestingly as well, there was a point about persistent identifiers, and the Office of the Attorney General confirmed that personal identifiers should be interpreted as a persistent identifier that can be used to recognize a consumer, a family, or device over time and across different services. And on this basis, if a session cookie is not able to recognize a user or a device or a family over time and across services, then it would not fall under the definition of personal identifier under the CCPA. So this is this is the key points that I wanted to mention. And then of course, as everyone is gearing up for the enforcement of the CCPA next month, California already cleared the way for the California Privacy Act, the CPRA, to be voted on as part of California's November 2020 ballot. So I guess this means that there will be changes to look out for in the coming weeks and months.
Thanks, Paul. And conscious of time, so we should probably wrap things up. And we're very, very happy to share the slide deck afterwards. And you'll see that the final slide gives you a summary of all of the different songs that have been captured in the various slides, if you're interested in finding out or checking that. But thank you very much for listening in today. Sorry to have overrun slightly, but lots to talk about. There are clearly a number of major developments in this area, both positive in terms of enhancing consumer and privacy protections, but also creating some challenges for the ad tech industry and ad funded content. So we'll wait to see how this all plays out. But I think what's clear from our discussion today is that the law is clearly driving change, but probably one of the bigger drivers of change here is not so much the legislative efforts, which have to some extent been unable to deliver the type of privacy protections that the law had intended, but we're really seeing that industry, the likes of Google, Apple, and the browsers, their plays to protect user privacy are probably going to be some of the bigger developments in the space and are going to have some really interesting impacts here. So yeah, lots to talk about. If you have any questions or want to have a chat with us about any of the topics, please feel free to reach out. But yeah, thank you very much for listening in, and keep an eye out for our next webinar. Have a lovely day, everyone.